is your duty to discuss the case in order to reach a verdict. Each of you must decide the case for yourself, but should do so only after considering the views of each juror. You should not hesitate to change an opinion if you are convinced it is wrong. However, you should not be influenced to decide any question in a particular way simply because a majority of the jurors or any of them favor such a decision. You may deliberate only when all of you are present in the jury room. You may not resume your deliberations after a break until all of you have returned to the jury room. In your determination of what the facts are, you alone must determine the credibility of the witnesses and the weight of the evidence. Page 2. You should use your common sense in considering the evidence, and you may draw reasonable inferences from that evidence. But in doing so, you should not indulge in guesswork or speculation. No comment or ruling I may have made during the course of this trial is or was intended to indicate my opinion as to what the facts are or that I believe or disbelieve any witness. It is the function of the jury to consider the evidence and determine the facts in this case. Following the court's jury instructions, the attorneys will have an opportunity to make their final arguments. The arguments are not to be considered by you as either evidence in the case or as your instruction on the law. Final arguments are intended to help you properly understand the issues, the evidence, and the applicable law. Excuse me. The attorneys, in making their final arguments, will be referring to the testimony as they recall it. I left a cup back in the back. I'm fine. I have coffee. Thank you. The attorneys will not knowingly misstate the testimony, but if their recollection of the testimony differs from yours, you should rely upon your own recollection of the testimony. You will be permitted to take your personal notes into the jury room with you, but please remember that your notes are for your own personal use only. 12 jurors are required to deliberate the case. Because we presently have 13 jurors, please remember that one juror will be randomly selected as the alternate juror who will be discharged prior to the case being submitted for deliberation. During your deliberations, you must not communicate with or provide any information to anyone other than your fellow jurors about this case. You may not use any electronic device or media such as a cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, any text or instant messaging service, any internet chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter to communicate to anyone any information about this case or to conduct any research about this case. You can only discuss the case in the jury room with your fellow jurors during deliberations. Please inform the court if you become aware of another juror's violation of these instructions. The reason you must not use electronic means to investigate or communicate about the case is because it is important that you decide this case based solely on the evidence presented in this courtroom. Information on the internet or available through social media may be wrong, incomplete, or inaccurate. You are only permitted to discuss the case with your fellow jurors during deliberations because they have seen and heard the same evidence you have. In our judicial system, it is important that you are not be influenced. Let me say that over. In our judicial system, it is important that you are not influenced by anything or anyone outside of this courtroom. Otherwise, your decision may be based upon information known only by you and not your fellow jurors or the parties in this case. This would unfairly and adversely impact the judicial process. Page 4. Under the evidence presented to you in this case, you may find the defendant Joshua Young not guilty, or you may find him guilty of the following offenses. Number 1, murder, as set out in instruction number 1, and or number 2, tampering with physical evidence, as set out in instruction number 2. Page 5 is instruction number 1, murder. You will find the defendant Joshua Young guilty of murder under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Jefferson County, Kentucky, on or about May 10 or 11, 2011, acting alone or in complicity with another, he killed Trey Zwicker. And B, that in so doing, he intentionally caused the death of Trey Zwicker. Once you have decided whether the defendant is guilty or not guilty under this instruction, you shall complete verdict form number 1. And the verdict forms come at the conclusion. They begin on page 10, and I'll get to those when we get to that page. There's a corresponding verdict form for each substantive instruction. Page 6, instruction number 2, tampering with physical evidence. You will find the defendant Joshua Young guilty of tampering with physical evidence under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Jefferson County, Kentucky, on or about May 11, 2011, he concealed clothing and or a murder weapon which he believed was about to be produced or used in a criminal prosecution, and B, that he did so with the intent to impair its availability in the proceeding. Once you have decided whether the defendant is guilty or not guilty under this instruction, you shall complete verdict form number 2. Page 7, instruction number 3, definitions. A, intentionally. A person acts intentionally with respect to a result or to conduct described by a statute defining an offense when his conscious objective is to cause that result or to engage in that conduct. B, complicity. A person is guilty of an offense committed by another person when, with the intention of promoting or facilitating the commission of the offense, he solicits, commands, or engages in a conspiracy with such other person to commit the offense, or aids, counsels, or attempts to aid such person in planning or committing the offense. Page 8, instruction number 4, caution to be used in handling exhibits. The jurors shall exercise caution when touching or handling any exhibit which may contain dried blood or bodily fluids. The court will provide a supply of latex gloves to be worn when handling the exhibits. Page 9, instruction number 5, presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. The defendant is not compelled to testify, and the fact that he does not cannot be used as an inference of guilt and should not prejudice him in any way. Instruction number 6, unanimous verdict. The verdict of the jury must be unanimous, finding the defendant guilty or not guilty, and must be signed by one of you as foreperson. You may use the forms provided at the end of these instructions in writing your verdict. Signed today in open court. Page 10 begins the verdict forms. This verdict form number 1 is to be used with the murder instruction, and the jury will find one of these two findings. Either we, the jury, find the defendant Joshua Young not guilty under instruction number 1, or we, the jury, find the defendant Joshua Young guilty under instruction number 1. Page 11 is verdict form number 2 to be used with the tampering with physical evidence instruction. Again, the jury will make one of these two findings. Either we, the jury, find the defendant Joshua Young not guilty under instruction number 2, or we, the jury,
An Amber Alert went out on June 16th, 2011 because people were scared that Joshua Young was dead. Because nobody could find him. And he almost was. And the way that you know that he almost was because when you heard from Aaron Specht, who came in and told you all about the horrific encounters she had with Joshua Yalker, the last thing that happened after she very intelligently escaped with her life was she said that Joshua Yalker forced her to look into the eyes of Joshua Young, who was terrified. You heard about that too. And promised that she wouldn't call the police because his life depended on it. His life depended on it. Everything Joshua Yalker says can be taken one of two ways. That's why you don't listen to him. That guy is not a mastermind. He is a puppet master. He's duped everybody. We meant what we said when we began. There isn't one assertion that you will hear from me or from the defense that has anything to do with what Joshua Yalker said. He said he's a liar, then immediately said, maybe I am, maybe I'm not. That's why you don't listen to him. If people wouldn't have listened to him, we wouldn't even be here. Do you really think he didn't kill Trey Swigert? Do you really think he didn't do that? Do you really think he involved anybody else at all? Anybody else at all to carry out this horrible crime? And it was horrible. And that's how you know who did it. By himself. He planned it. For 10 years, he planned it. And I mean what I'm saying. Cassie didn't take anything anywhere, but we'll get to that. Because that's how he gets you. As long as you're scared of something, and always him, or being prosecuted, or some consequence, you will do what he says. And you'll tell the truth because your loyalty lies with him. Because they know everything. Just put him aside for a minute. There's not much else to talk about, but let's just put him aside. Because I know you probably expect me to get up here and rant and rave about Joshua Yalker, and how could I not? But that's not all this is about. There are two main areas you just need to kind of categorize and think about as you deliberate back there. There are words. There are so many words. When he was up here and he was being questioned by the prosecutor, something about the media came up. And you know he loved being up there. And I think it was put to him, some people just love to talk. That's true. Some people listen to that. Don't listen to it. You don't believe him anyway. And I know that the way that all of this evidence came in was rather confusing. We called some witnesses out of order. And different people were able to be here at different times, and so it was just kind of jumbled coming in, and I'm going to help you straighten that out. This is not a difficult case at all. This is a really typical, horrible situation involving domestic violence. And let me stop right there. This isn't about demonizing anybody. Amanda was being abused. I mean, let's get past that. It's not about putting her down or anything else. This was a household full of domestic violence. This crazy guy comes home from prison in October 2010. He walks right out and right to her. And that's where he began manipulating everybody and duping them. We defined duping, you know. And he laughed. He laughed about a lot of stuff. And you can't blame anybody for getting duped by him because he's really good at it. Superficial charm. Immediately like him. Immediately like him. Don't feel bad if you found yourself laughing at some of the stuff he said, because he's good at it. After he began talking with Amanda, it wasn't long at all before he was living there. He also walked right into a social worker's office and sat down and said, I want my son back, I'm going to do this right. And you know, when he was talking all about that, and we were talking about duping people, he was like, well, you know, it took me a little longer with them, but I cried, and he cried. He can cry just like that. You saw his mood go back and forth on a dime. Don't think he's not in control of that. Sometimes when people don't cry, inferences are drawn. Sometimes when they cry appropriately, inferences aren't drawn. Obvious ones. He went to probation and parole and gave him a false address, which he maintained for some time. Indicated he changed his address, take that or leave it, I don't care. They lied to him. That's the third set of people he duped in days, weeks maybe, days.